Subscribe to our YouTube channel and press the bell icon to get the latest updates.
The death of a pregnant elephant in Kerala last week evoked nationwide uproar. So we began KYC or Know Your Constitution this week by taking you through some court judgments which have extended the right to life to animals as well. The first such judgment was passed in 2018 by the Uttarakhand High Court, which declared the entire animal kingdom as legal entities capable of defending themselves in court. The ruling followed the High Court's trend of declaring rivers, glaciers, and forests as legal entities to protect the environment. Following this, in May 2019, the same judge who delivered the Uttarakhand High Court judgment delivered a similar judgment after being transferred to the Punjab and Haryana High Court. The basis of both these decisions was a Supreme Court judgment passed in 2014 when the court had pronounced that every species has a right to life and security, and said that the word life includes all forms of life, including animal life, which are necessary for human life. In October last year, the Tripura High Court also banned sacrifice of animals and birds in the temples of the state, observing that the animals also have a fundamental right under Article 21 of the Constitution of India. So to break it down, the courts in India have extended the right to life to animals as well and have granted them personhood, but the principles are at a very nascent stage in India, so there's little clarity as to what sort of rights the animals actually have. The COVID-19 pandemic is exerting considerable strain on the healthcare facilities in India. So on KYC Next, we told you about the fundamental right to health and the government's consequent constitutional duty to guarantee health facilities to all citizens. Now, the right to health is not expressly mentioned as a fundamental right in the Constitution. However, through a series of judgments over the past 2 decades, starting from Consumer Education and Research Centre versus Union of India, the Supreme Court has recognized the right to health and said that it flows from Article 21 of the Constitution. Naturally, the right to health requires certain steps to be taken by the central and state governments to ensure that the entire population has access to this right. So, in a 1996 judgment, the Supreme Court had observed that providing medical facilities to all citizens is a constitutional obligation of a welfare state. It said that in order to discharge this obligation, running hospitals and providing medical care to those who need it is actually a requirement under Article 21 of the Constitution. Notably, the court also pointed out that the government cannot ignore its constitutional obligations, in this case providing healthcare facilities to people, by citing lack of financial resources. In fact, relying on this judgment, the Delhi High Court had in 2018 also declared it unconstitutional when the Delhi government at that time denied certain medical facilities to non-Delhi residents. From novels to condom packets, India's obscenity law has often been invoked to censor free speech. So on KYC, we told you what the law says and how the Supreme Court has interpreted it. Decency or morality is one of the grounds restricting the freedom of speech and expression under Article 19(2) of the Constitution. Now, obscenity is criminalized under Section 292 of the Indian Penal Code, which is a Victorian-era legislation used in the past to unsuccessfully prosecute Ismat Chugtai and Saadat Hasan Manto. After the Constitution came into force, Section 292 was challenged as being violative of the freedom of speech and expression under Article 19(1)(a). But the provision was upheld in 1964 in a case which also involved a challenge to the publication of D.H. Lawrence's book, Lady Chatterley's Lover. In the same case, the court went on to define obscenity and adopted a test which judged obscenity from the point of view of those who were morally weakest and most corruptible in the society. This therefore set the bar very low for obscenity. But over the years, this standard has been replaced with another one which instead focuses on defining obscenity from the standpoint of an average, strong-minded and reasonable person. So for instance, the court quashed several complaints of obscenity against Tamil actress Kushbu, who supported a woman's right to premarital sex in a magazine interview. The movie Bandit Queen was also banned on the ground of obscenity because of a very brief frontal nudity scene, but the Supreme Court struck down the ban, observing that nakedness per se isn't obscene. However, the court has also upheld curbs on free speech on the grounds of obscenity several times. For example, the Supreme Court refused to quash the obscenity charges against the poet of a Marathi poem called Gandhi Mala Bhetla, which translates to I Met Gandhi. The court said that the poet must face trial and that obscene words cannot be used against a historical personality like Mahatma Gandhi. Ever since the nationwide lockdown was imposed to tackle COVID-19, several reports have emerged showing the difficulties being faced faced by people to get access to even the most basic necessities, including food. So in KYC, we told you about the fundamental right to food and a landmark Supreme Court judgment which is also called the right to food case. Now, the Supreme Court has observed several times over that the fundamental right to life under Article 21 of the Constitution includes the right to live with human dignity, which in turn includes the right to food and other basic necessities. This right has also been linked with the directive principles of state policy. Article 39A directs the authorities to ensure that all citizens have the right to an adequate means of livelihood, and Article 47 says that it should be the primary duty of the government to raise the level of nutrition and improve public health. However, one of the most notable developments on the right has been the PUCL versus Union of India case, more popularly known as the right to food case. The case began in 2001 after 47 tribals and Dalits starved to death in Rajasthan as the state reeled from its third consecutive year of drought. During the hearing of the case, the National Human Rights Commission also endorsed the fundamental right to be free from hunger. Over the next 16 years until 2017, the court monitored every government scheme related to food, its implementation, both at the state and central levels, by appointing its own officers to bring ground reality to the courtroom. These orders also gave momentum to the right to food movement on the ground to mobilize around the court's orders. The case is credited with endorsing the principle that people are legally entitled to the government's food schemes in light of their constitutionally protected right to food. The beneficiaries of these programs were also transformed into stakeholders of a justiciable right, meaning that these rights could be enforced in a court. The Supreme Court over the years has expanded the right to life and liberty under Article 21 to include several other rights. One such right is the right to die with dignity, and that's what we told you about next on KYC.
The debate around the right to die actually began in context of Section 309 of the Indian Penal Code, which criminalizes attempt to suicide. The Supreme Court, however, back in 1996 rejected the contention that the right to life included the right to die and upheld Section 309. The right was debated on widely once again when a journalist approached the court on behalf of Aruna Shanbag, a nurse who lived in a vegetative state for decades after being raped. She requested that the hospital doctors be directed to stop feeding Aruna and let her die peacefully. While the two-judge bench in 2011 recognized passive euthanasia, it did not allow it for Shanbag, who passed away in May 2015. In passive euthanasia, the patients die because life support machines that keep them alive are removed. As against this, in active euthanasia, medical professionals actively act on the patient's desire to die, say by giving them injections or medicines. However, since doubts on the correctness of this judgment cropped up, a 5-judge constitutional bench finally settled the law in 2018, declaring the right to die with dignity as a fundamental right under Article 21. As for Santhara, the Jain practice of fasting unto death, the issues involved are a little more complicated as two fundamental rights are involved: the right to life under Article 21 and the right to freedom of religion. This perhaps I will deal with in another edition of KYC.
This is Apoorva Mandhani for ThePrint. Do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.